I'm going to introduce our faculty sponsor, Curtis Bradley, Professor of Law here at Duke University, and he's going to moderate today's debate. Professor Bradley.
Welcome everyone to the debate we'll have today on the topic of stare decisis, which probably many of you know is a doctrine that courts at least discuss and sometimes follow with respect to adherence to prior decisions, holdings, and precedent. We have, fortunately, two very preeminent constitutional law scholars here to debate the desirability of stare decisis, both named Michael, it turns out, and both individuals, it turns out, who were at other law schools for a very long time and relatively recently have joined new law faculties. To critique the doctrine of stare decisis, we have Professor Michael Paulsen, who is now professor at the University of St. Thomas School of Law in Minneapolis. But for many years, those of us who have known him for a while identify him with the University of Minnesota Law School, where he was there for quite some time. He has written, both of these individuals have written extremely widely in areas relating to constitutional law and actually other topics, but Professor Paulsen's written about law and religion, constitutional history, and most relevant to today, about stare decisis. Professor Michael Gerhart is now a professor at nearby UNC Law School, but for many years was at William & Mary Law School. He is the author of several books, including books on impeachment process and the federal appointments process, as well as, I think, something more than 50 articles, I think, on topics relating to constitutional law, but also federal jurisdiction and the legislative process. The format of the debate will have Professor Paulsen begin with a critique of the doctrine of stare decisis. I've asked him to speak for around 15 minutes or so, and then Professor Gerhart will respond for up to about 15 minutes as well, and then they'll have the option of a few minutes each of a rebuttal if they choose to exercise that right. And we would very much like to have at least 10 or 15 minutes near the end for your questions about what you've heard from the debate. If it starts to come to blows, I will be sitting over there and eventually start to intervene and order them back to their corners, but I suspect it's probably not going to go that far. I really look forward to the debate. Professor Paulsen.
Thank you, Kurt. No, it won't come to blows. Michael and I are old friends and sparring partners. When I was at University of Minnesota, I tried to recruit him actually to be our dean, and then when that didn't work, to be a law professor. The guy kept saying no. I don't know. He's something about, you know, the Carolina blue colors, but you know. But it is my first time here at Duke, and I'm convinced that God must not be a Tar Heel because the sky is not Carolina blue. I've passed out a Duke Blue Devil blue handout, right? So you may pass it around, and you'll have a basic idea of where I'm headed with this and how close I am to finishing on time, which won't be very close. It's an honor to be here. Thank you to the Federalist Society. It's kind of ironic that the stark raving mad liberal is going to be defending stability and precedent in the status quo, and that the Federalist Society conservative is going to be in favor of tossing it all out the window. Stare decisis is one of those kind of doctrines that conservatives, Federalist Society types, tend to like, right? It feels conservative in a sense. And liberals at least play lip service or pay lip service to stare decisis. They like to adhere to precedent when it's convenient to do so. And lawyers and law students are very much trained in precedent and the common law method. And so at some level, the doctrine of stare decisis is a proposition that everybody embraces to some degree or not. Okay, and my proposition today is that everybody is wrong. I'm going to take the position, and I'm going to defy you to at least start thinking about it. Okay, I'm going to take the position that stare decisis, at least in the area of constitutional law, is not just a bad idea. That stare decisis, in fact, is unconstitutional, and that no judge or court should ever knowingly adhere to a precedent that he or she is fully persuaded is wrong on the grounds of stare decisis. That stare decisis, in that strong sense, is unconstitutional and disserves all of the supposed rule of law values. that it's thought to further. Now, I started on my outline by a definition. I'm going to stack the debate just a little bit, okay, by introducing what exactly I mean by stare decisis. And by stare decisis, I mean the proposition that a court should adhere to a prior decision whether or not mistaken. Those quotation words come from the case of Planned Parenthood versus Casey, the 1992 decision reaffirming, more or less, Roe versus Wade, and sort of the court's first systematic discussion of stare decisis after 200 years of being in existence. They define, operationally at least, the idea of stare decisis as adhering to a decision whether or not you would otherwise agree with it. Now, in other words, what makes stare decisis a doctrine with any sort of kick or bite at all has to be the proposition that you're deciding a way you otherwise would think is wrong. Because you don't really need a doctrine of precedent or stare decisis to decide a case the way you think is right in the first place. Okay? If that's what stare decisis means, it's a complete make-weight. Okay? What gives the doctrine any content at all is that you're adhering to it even though you would otherwise think it's wrong. Okay? Now, I'm not for throwing precedent all out the window, okay? I think you don't ignore precedent entirely, but what I do is I distinguish between, what function it is that precedent is supposed to serve. It serves an information function. You get the benefit of other people's prior thinking, and maybe it serves as a baseline or a starting point, and you have to persuade yourself or become persuaded that a decision is wrong in order to depart from it. In that sense, precedent may serve a baseline justification function too. You've got the benefit of someone else's thinking, and if you're going to depart from it, you kind of need to have a decent explanation of why the precedent decision is wrong. But I distinguish that from what I've called in this article I cite, the disposition function of precedent. That is a function of precedent that says, we're going to look at precedent not for the information it conveys, not for the benefit of prior thinking, but to tell us what to decide, independent of how we think about it or not, okay? That is a pure disposition function. That is the function that I think is totally illegitimate, and that is the core of the doctrine, as I understand it, of stare decisis. So let's get on to the 4 big lies about stare decisis. Will the cameras mind if I take this off and get all warm and heated about this? Lie number 1, stare decisis is constitutionally required. Now, you rarely hear this lie expressed in direct terms. Usually it's said something of the effect that stare decisis is an important part of the rule of law, respect for precedent, it serves rule of law values. But the strong version of it that seems to be lurking behind many discussions of stare decisis is that in some sense stare decisis is part of what the Constitution means. Big lie. The Supreme Court itself has even said innumerable times that stare decisis is not a doctrine of constitutional dimension, it is a judicial policy, a pragmatic practice, not a strict rule of law. And an important further thing to add is that stare decisis, at least in the American legal system, has never been thought to be strict. It's never been a requirement that courts must follow a prior precedent. There's always been room to overrule prior decision upon a sufficient justification. My position is that not only is stare decisis not required by the Constitution, as the Supreme Court concedes, but that stare decisis is forbidden by the Constitution. Okay, no, hold on, don't run out yet, okay, unless you're getting more pizza. Okay. Here's the basic argument, and the argument is one that I take from Marbury versus Madison about the nature of the Constitution. I've cited this article that I wrote a couple years back called The Irrepressible Myth of Marbury. Okay? Marbury says, if they teach it to you right at Duke Law School, that the Constitution is supreme law, and that any act of a mere subordinate agency, contrary to the Constitution, loses. So if the Constitution says one thing and a statute says another, the Constitution must always prevail over the faithless departure from it. That's the core of the argument for judicial review, is that the Constitution trumps an inconsistent application of it. Think about it. Why isn't that exact same argument applicable to precedent? If the Constitution says one thing, and a judicial precedent says something to the contrary, so that there's a contradiction between the meaning of the Constitution and what the court has held, you must always give precedence to the Constitution over precedents, right, so to speak, okay? The Constitution should always trump a judicial decision contrary to it. At the end of Marbury versus Madison, Chief Justice Marshall gets all stirring and impassioned in his rhetoric. He said, to abide by the faithless departure from the Constitution, rather than the Constitution itself, would be a violation of the judicial oath. It would be a crime, a mockery, to adhere to what you knew was not the rule of the Constitution rather than the Constitution itself. Well then, I submit that it would be a crime, a mockery, a violation of the judicial oath for any judge knowingly to follow what they are fully persuaded is an incorrect interpretation of the Constitution and to put that above the Constitution itself. It departs from the rule of Marbury versus Madison. Now, of course, I've cited Marbury versus Madison not as controlling precedent, right? I cite it for its persuasive and information function only. But for those people who worship at the altar of precedent, the reasoning of Marbury would be a worthy precedent if ever there were one, right? So, it follows from this, I think you can apply this reasoning across whatever interpretive theory you have about the Constitution. And that's a citation to this really short article I published about a year or so ago called The Intrinsically Corrupting Influence of Precedent. Whatever your theory of constitutional interpretation, if you then add a theory of stare decisis to qualify or mitigate your interpretive theory, you are always corrupting the original. If you're an originalist, very few of those endangered species around Duke Law School, and you think that the Constitution, that the meaning of the Constitution is the original meaning the words would have had in context to reasonably informed speakers and readers of the English language at the time the document was written, if you then add a theory of stare decisis, as Scalia does, as Bork does, to qualify it, you're really impeaching the rationale for your original interpretive theory. If the essence of originalism is that the original meaning of the words is what controls and nothing else, if you add in a theory of stare decisis, you corrupt your originalism theory. You also corrupt your non-originalism theory. If you believe that judges should interpret the Constitution so as to further important social policies, values, pragmatic outcomes, or whatever the result-oriented interpretation of the day is, why on earth would you let precedent stop you? And of course, the reality is that it doesn't. Now, if my argument that stare decisis is unconstitutional is right, then I don't need the rest of this in order to have demolished my opponent in the debate, right? Because if stare decisis is unconstitutional, in the strict sense of adhering to a decision you're otherwise fully persuaded is wrong, then that's it. That's the end of the argument, okay? But I'm going to go on and talk about the policy arguments that are usually asserted in defense of the doctrine of stare decisis. But when you get there, I think that you find that the policy arguments all get undermined by the way stare decisis is actually interpreted and applied by the Supreme Court. The real problem is the policy arguments that are put forward for stare decisis, if you take them seriously, they prove way too much. And if you don't take them seriously, if you're inconsistent or waffling in your application of them, it ends up undermining all of the arguments that are supposed to serve. Okay, and let me just go through them one by one. Big lie number 2 is that stare decisis produces efficiency and stability in judicial decisions. Now your first instinct, being sophisticated first, second, and third year law students, will be just to laugh, right? Because our whole thing is like reading one case and then reading the second case and seeing how it's inconsistent and distinguishes the other and the third. And you know, if this is efficiency, we haven't seen anything like efficiency. And the comparison that I would constantly be drawing is between the use of precedent for its information function and for its disposition function. If you're talking efficiency, there is an efficiency gain to having the benefit of someone else's prior thinking of the issue. It is useful, usually, to read precedents to see what someone else has thought. Sometimes, of course, it can just be confusing and add layers of complexity needlessly. But there is a benefit to seeing what someone else has thought. But given that the doctrine of stare decisis has never been absolute, the way you would be following precedent now is you look at the precedent, try to understand what it says, not just for its information or persuasive value, but because at some level you have to follow it. but that level is itself unclear and involves application of a complicated 20-page doctrine of stare decisis, which is unclear in its application. So if you have a view of precedent as involving not merely the benefit of prior thinking, but the inconsistent thinking about the prior thinking and the layer on top of it, the doctrine of stare decisis, you don't have a very efficient system or a very stable system after all. The reality, of course, as I always told my law students, you know, in your first couple of weeks of constitutional law, they say, well, what is the rule? What is the rule, the practice of the Supreme Court with respect to precedents? And it's a very easy laugh line, is that the Supreme Court follows precedents except when it doesn't. You know, and that is the reality, isn't it? Right? You've run enough cases to know that this is the truth. And the further reality is that the process of disregarding prior precedents is often Subrosa. It's driven underground, right? A prior decision is distinguished away. And then you have to reconcile the two somewhat inconsistent decisions. You get another decision that's really not very consistent with either of the first two. And then you get to a fourth decision, which then tries to harmonize the three decisions and thinks they can all be explained by some three-part, two-pronged, multi-layered tier of scrutiny test that starts to make your eyes glaze over. And, you know, at some point you just have to say, the emperor has no clothes. Okay? This really isn't a system of stare decisis. This is a system of fake stare decisis, and that's inevitable when you give lip service to stare decisis but don't really truly believe in the values it's supposed to serve. Some examples from last year's Supreme Court decisions. Gonzalez versus Gerhart is the decision of the Supreme Court last term upholding the federal partial birth abortion statute. In 2000, the Supreme Court decided Stenberg versus Gerhart, striking down Nebraska's partial birth abortion prohibition. Now, the core difference between the two cases is a change in judicial personnel. Okay? The one was 5-4 striking down in 2000, and last year's was 5-4 upholding it. None of the 9 justices believes that both cases are right. None of them do. But the way that the Gonzalez decision is written is all working within the supposed Stenberg versus Gerhart framework, distinguishing it to oblivion on the ground essentially that case was decided on Tuesday and this case is decided on a Thursday and the personnel have changed, but not admitting it. I think what this does is it turns the idea of stare decisis into a cruel hoax. And my talk tomorrow at University of North Carolina, Michael is hosting the symposium, is entitled, sort of gently mockingly, does the Supreme Court's current doctrine of stare decisis require adherence to the Supreme Court's current doctrine of stare decisis? And I look at all the factors that the court looks at to decide whether a case should be overruled or not, and find that the doctrine of stare decisis, applied to the doctrine of stare decisis, would not lead you to continue to adhere to the doctrine of stare decisis. So, how's that for efficiency and stability functions it's supposed to serve? Okay, I better get into 2-minute drill now. Turn to lies number 3 and lies number 4. Lie number 3 is that stare decisis protects reasonable reliance interests. But again, you have to mitigate this by the fact that stare decisis is not and never has been absolute. Given that stare decisis is not absolute and that courts will overrule cases in appropriate circumstances, the doctrine becomes unpredictable and it really becomes weird to adopt a conception that you are going to rely on a precedent not being overruled when the doctrine itself admits of precedents being overruled on a mixture of uncertain criteria. And in a prior article, I've distinguished between what I call predictive reliance and a term I made up, stare decisis reliance. When you're a lawyer advising a client, there's always some sort of prediction about whether the legal rule announced by the court will continue to be the legal rule in a subsequent case. And a good lawyer will discount that by an appropriate amount, taking into account the fact that legal rules change or interpretations change. Okay? To some extent, though, you can always predict with a modest degree of certainty, whether a rule will continue to be applied or not. Stare decisis reliance is, I think, unreasonable reliance in the sense that you're adding on top of your predictive reliance some measure of reliance on the Supreme Court's adhering to its own conceptions of stare decisis, which, if you think about it, becomes an oddly circular enterprise. And if you look at the Supreme Court's practice of precedent, you can see that the court's reliance on the idea of reliance has become very unreliable. Okay? In the past 15 years, you see Casey, which nominally reaffirmed Roe, but overruled 2 cases. 2 years later, in stare decisis, notwithstanding the doctrine of stare decisis, in the case of Adirondack, they overruled Metro Broadcasting on federal affirmative action. In 1997, in a case called Agostini, they overruled Aguilar versus Felton on interpretation of the Establishment Clause. Then in 2000, in Dickerson, they adhered to Miranda because stare decisis requires it. But then in a couple of death penalty cases, minors' death penalty, mentally handicapped death penalty, they overrule prior cases. And then in the mother of all stare decisis cases, Lawrence versus Texas, the same justices, many of them who affirmed Roe on the ground of stare decisis, overrule Bowers versus Hardwick, saying that stare decisis cannot require us to adhere to a prior decision that we are fully convinced is wrong, especially if there's been a lot of criticism of it. So how much reliance can you put on the Supreme Court's adhering to decisions in order to protect reliance interests? Again, I think it's essentially a hoax. Last point follows from all the others. It is a lie to say that stare decisis promotes fairness and equal treatment and respect for the judiciary. Now, there's something to this intuition that like cases should be treated alike. But remember, as long as stare decisis is not absolute, there's always this escape hatch for overruling, and some cases that are alike will not be treated alike. And the reason for that is the court has become persuaded that the prior decision is in some meaningful sense wrong. And the intuition there is also an important justice intuition, that you don't adhere to a wrong decision out of a supposed sense of fairness. Now, I have 2 kids. One's 15 and one's 9. And I always tell them that I've made a bunch of serious parenting errors with respect to the 15-year-old, and therefore I should repeat those errors with respect to the 9-year-old out of a sense of fairness, right? Isn't that the essential intuition of the fairness argument for stare decisis? Because remember, the assumption of the doctrine is that you would otherwise conclude that the prior decision is wrong and should be overruled. But I'm going to adhere to it anyway in the name of fairness. Or, I think the ultimate canard, in order to have people respect judicial authority. Now, should my 9-year-old respect me more because of my stability and consistency and repeating an error as to her that I did as to her big brother? Does that really further respect for judicial authority? You know, I'm not buying it, and my gut is that you're not buying it either. Now, my final point is that taken seriously, this idea that respect for the judiciary requires it to adhere even to decisions it thinks wrong, would lead you in Brown versus Board of Education to reaffirm Plessy versus Ferguson. A number of years back, I co-authored with a student of mine a satire. We took the reasoning of stare decisis as set forth in the Casey decision as to abortion and wrote it up as a mock decision reaffirming Plessy in Brown versus Board of Education. And then we sent it out to law reviews saying that we had, with sort of a straight-faced introduction saying we discovered this in the Thurgood Marshall papers while doing some research in the library. And it was an early rough draft, and I won't tell you which law reviews bought this, but they were saying, wow, what a great discovery. Can you send us a copy of the original? And even some law professors and historians said, this is an amazing find, you have to say. But it was all a satire. We just applied the same reasoning, and if the arguments for reliance, stability, faithfulness to what has been decided before have any cachet, they would lead you to reaffirm Plessy versus Ferguson. That's the way we wrote up that opinion. That's a fun one to read, the NYU Law Review article, and read it in one good long bathroom sitting. When I teach con law, near the beginning when I teach Marbury versus Madison, because you're all inculcated into this idea of judicial authority and supremacy, I pose to them this hypothetical or something like it. Congress passes the Sedition Act of 2007 that makes it a crime to criticize the government of the United States. And you get no trial, and you're supposed to be immediately executed that afternoon, and the conviction will work a forfeiture of all assets and corruption of blood for the next 4 lineal generations of descendants. Okay? As unconstitutional a thing as you can imagine. Then assume the Supreme Court has upheld it in the first case, United States versus Paulsen, and they affirm the conviction. A second case comes up, United States versus Gerhart, when he has also criticized the government of the United States. Should the Supreme Court adhere to its precedent in United States versus Paulsen and execute Mr. Gerhart on principles of stare decisis and respect for the law? And darned if I don't get students who say, yes, that is the essence of the rule of law. My argument is that stare decisis, if it means that, is an utterly pernicious and unconstitutional argument, except for when it's a mere dishonest hoax or cover for what the court was going to do anyway. And I defy Professor Gerhart to embrace his own execution. So.
Let me begin actually on a personal note. I appreciate the opportunity to be here. It's always a pleasure to drive these long 8 miles that separate us. And most importantly, I want to just say that one of my favorite people in the world is Mike Paulsen. I think you can see what a wonderful teacher he is. I can only imagine what he must have been like as a student. But it's always one of my great hopes in life to be as entertaining and provocative as he is. I doubt I will ever achieve that, but you have some sense of what a great joy it is just to be a friend of his. Now, having said that, let me also sort of then talk about let me just make sort of 2 minor distinctions at the outset, and then I want to sort of talk about why much of what Mike has said may not be quite as persuasive as it might sound. The first is just a note about parenting. I have 3 kids. And while Mike is right that one might not want to perpetuate the errors that you might have made in the past, we all would hope to learn from our own experience. I do think that one thing you'll discover if you're not yet parents is in fact the utility of precedent. That is to say that if you find that something has worked in the past and in fact it becomes quite important to say to your children, we're going to try in fact treat you each equally. That is to say, if we've got a way of doing something in this house and it's worked, this is how we will continue to proceed. Now we'll continue this discussion until my kids are in college, I guess at least, but I will benefit from any advice anybody's got to give on parenting. But I think a solid beginning, however, is in fact to recognize that while you've got to be open to recognizing you make mistakes, of course, but you also have to recognize that in order for your household to work, your children are going to want to be and need to be treated to some extent equally and on the same ground. That may also apply in a different forum, but we'll come to that in a second. The second is, let me just change the hypothetical on Brown, because I'm a law professor and I can get to do that. What if, in fact, you did discover some incredible document, not from Thurgood Marshall, but let's just say there was this magical thing that you could somehow find from the Reconstruction Congress that showed that, in fact, they were absolutely unanimously agreeing that whatever they were passing in the form of the 14th Amendment was not meant to displace state-mandated segregation of the races in public facilities. Let's say that was just somehow there, that you could find that, and that came to light today. How many here think the Supreme Court would ever overrule Brown versus Board of Education even in the face of that document. And my guess is you might get one vote, but I doubt you would get any more than that. That tells you something about precedent right there. But let me tell you a little bit more about precedent. Let me state first, I think, with all due respect, Mike might get the statement of the law wrong here. The point is not that the law says that stare decisis is constitutionally required. I think what the law suggests is that stare decisis is constitutionally allowed. And those are two very different things. To begin with, nobody's suggesting that precedent is compulsive or compulsory or necessarily constrains a court or any other institution from forgoing a certain path that it may want to go. But the critical notion of precedent or stare decisis, I think, does have some constitutional authorization, which is not to say that one is compelled to follow it. Those become two different things. The Constitution in Article 3 explicitly provides that the federal jurisdiction extends to all cases arising under the Constitution. One could infer from that, I think, the power of a court to then decide a case that involves the Constitution, that it in fact arises under the Constitution. Such a case constitutes, among other things, a precedent. That precedent endures until or unless the court displaces it or there's a formal constitutional amendment. I think the authorization for regarding something as a precedent actually can be traced back to the actual language of Article 3. And I think that's how the Supreme Court and other institutions have understood that language from the beginning. Beyond that, let me state a second point. I'm just recognizing the Constitution allows this so-called doctrine of stare decisis. Not that it compels anybody to follow any particular decision, but merely allows a court, of course, which is how courts have operated since almost the beginning of time. And that's in itself rather significant. In other words, the framers enacted the Constitution with the understanding that courts, in fact, do recognize and follow and live with precedents all the time. That's really their lifeblood. That's the main sort of dynamic with which they live. But let me sort of come to a second point. The second point is just that I think what you'll discover is that precedent isn't ever, or almost isn't ever, the sole consideration in any given case. It's just one of a number of different considerations. Or as some people would like to suggest, it's one of the modalities of constitutional argumentation. It's one of about 5 or 6. And it's one of the ones that's most commonly used. And that's how it arises. It doesn't arise typically in a setting in which the court or judges are looking only at precedent and nothing else. It's usually part of a mix of things. So we can't ignore the fact that that mix is really a more accurate description of how cases are actually adjudicated or decided. But here I want to make a third and maybe much more important point, and that is that precedent or stare decisis, whatever you want to call it, is needed as much by Mike as it is by anybody else. He's going to need it in order for his judicial system to operate. For without it, let's just imagine how what's going to happen to his precedents. What's going to happen to the precedents that he likes, that he would prefer for courts to follow, or courts to accept, or even just to the extent of persuasive or useful reasoning. And that's really ultimately, I think, all as much as precedent really ever does, is provide some kind of information or a justification, as Mike has described. I think beyond that, I think we are perhaps exaggerating to some extent the influence that precedent may have in the actual process of constitutional adjudication. So this leads me to the recognition of another point, and that is, in the world of constitutional law, what you see is a different operative principle than the one I think Mike has described. What I think you see operative is what I describe as a golden rule of precedent. Now, it just so happens I have the page proofs for a book on precedent sitting on my desk back in Chapel Hill. The good news is the page proofs are not due for a few weeks, so I had the benefit of being able to modify anything I say there based on what I learned here today or am persuaded otherwise to believe afterwards. But one thing, in fact, that I think you see operative in the dynamic of constitutional adjudication is something much more like a golden rule, which is to say that justices simply will recognize early on that they have got to provide some degree of respect for the precedents of others, or they can expect that their precedents, the ones they like, will just receive the same disdain they've shown for other people's precedents. In other words, you've got to begin to treat some precedents, even though ones with which you disagree, with some degree of respect, if you expect others to join the ones that you like or to support the ones you like. That's an essential dynamic which has existed, I think, almost from day one of the Supreme Court. And in fact, let me read to you an authoritative statement from someone whom you might expect to believe in the policies that Mike just described, but doesn't. This is from my former professor of constitutional law. And if I can read you'll have to excuse me, I'm going to try and read my own writing, which is one of the hardest things in the world. But here's what he said. Originalism, like any theory of interpretation put into practice, is an ongoing system of laws, must accommodate the system of stare decisis. It cannot remake the world anew. Originalism will make a difference not in the rolling back of accepted old principles, but in the rejection of usurpacious new ones. That's Nino Scalia talking. And that's Nino Scalia talking recently as a Supreme Court justice. So Justice Scalia obviously accepts this doctrine because I think he recognizes this golden rule, but also he recognizes that all these other benefits from precedent, which I think are perfectly consistent with every authority of constitutional meaning, is a fundamental part of our constitutional life. Now, having said that, let me also just relate to you a few interesting statistics. These are statistics we pulled together for this book that, if I'm lucky, is still going to get published. At least that's what Oxford University Press thinks, but we'll see. But here's some statistics from the last two terms, 2006 term, 2007 term, 2005 term, 2006 term. And it's really quite interesting. If you look at how, and we figured out these statistics for every justice, in all the constitutional cases decided in each of these terms, in every single one of them, there's only one source of decision that's relied on in all of them, and that's precedent. If you look at any other possible source of decision, let's say original meaning or structure or even text, they're not cited in all the same cases. Now, more importantly, let me tell you the following statistics. Here's something, let's look at John Roberts' decisions, the Chief Justice decisions. Let's look at the opinions in which he wrote and the opinions in which he joined. In 100% of those opinions, he relies on precedent. Do you know how many times he mentions original meaning in over 30 constitutional cases? 3 times. Precedent in 100% of the cases, original meaning 3 times. What about Justice Thomas? Justice Thomas relies in the 2006 term on precedent in 38 of 41 cases. How many times does this adherent to original meaning rely on that explicitly? 5 times. Nothing else comes anywhere close to precedent as a basis for a Supreme Court decision. That's not to say it's the only basis, but it is to say it's a persistent and enduring one. And here I'm talking about precedent in an abstract, categorical sense, and not particular precedents, and we have to make that distinction as well. Precedent as a category of argumentation, as a mode of argumentation, is, I think, a fixed part of the dynamic of constitutional adjudication. And this, of course, is only the court we're talking about. We haven't yet even begun to mention how other public authorities treat precedent in the work that they do. So how does Congress or how do presidents deal with precedents? That is to say, the prior constitutional activities of their predecessors in office. And what we discover is they need precedent too. This isn't to say that they don't feel free to try to build the world anew. But just like Justice Scalia, they recognize that it makes their world much more manageable, and that it's part of the framework within which they operate, as Mike himself, I think, just described a few minutes ago. Now, beyond all of these other things, beyond these various things that I've mentioned, I want to come back to the notion that Mike's mentioned about how precedent doesn't necessarily sort of bind judges or justices in cases where they don't want to be bound. Let me make absolutely clear. In fact, many of you may already know this. If you look at how political scientists look at precedent and study precedent, and they study it empirically, what they will tell you is that precedent rarely constrains a court or justices from doing what it wants to do. So a particular precedent doesn't really require that much from a court. It almost never really requires that much from a court. Again, I think it serves particularly the purposes that Mike just described, though it may help provide some of the foundations for certain things. For example, whatever one thinks about Marbury versus Madison, the institution of judicial review, which it helped to recognize, is clearly an enduring feature of our constitutional system. That's grounded in many things, one of which is precedent. It's not to say that maybe I can't envision, or we couldn't envision a world which didn't have judicial review, but it is to say that that's become entrenched as part of our constitutional system. That's just one of the many institutional practices which courts may have recognized and is supported in part by precedent, but there may be others. Now, as far as the constraining power of particular precedents is concerned, I think we need to separate that from whether or not precedent, as a more general matter, ought to be able to serve as a basis for decision. And I think the answer to that is, yes, it should be able to do that. I think that's consistent with the constitutional structure. But again, we can recognize that there may be individual cases, a lot of individual cases, maybe even most individual cases, in which particular precedents do not dictate particular outcomes. In fact, I think the data on that is overwhelming. It's just not very strong. Even apart from Gonzalez versus Gerhart, you can find other cases. Let me give you an example of one of them, Brown. Now, Brown itself recognizes, as you might recall from constitutional law, at least 5 different theories for what it holds. Yet, the Supreme Court in the Seattle and Louisville desegregation cases recently held that Brown nor its progeny in no way dictates that cities could adopt voluntary desegregation plans. And the court used strict scrutiny and found, among other things, that these plans weren't narrowly tailored. Now, were those findings by the court in any way inconsistent with Brown or undermine Brown? I don't think so. I think that what happens in those cases is that the court is in fact construing prior precedent and figuring out, in a sense, the extent to which it may be helpful to either follow it here or understand it in a certain way in this particular case. That's a very common activity, but it has nothing to do with the fact that the court is sort of overruling or undoing Brown at all. It just means that Brown didn't constrain the outcome. That's all it meant. And what it also means is that the meaning of any given precedent depends much more on what subsequent justices think about it than what the justices who create it thought it meant. And you can see this dynamic also throughout history. And what this gives rise to then is the recognition that precedent is only ever going to have any meaning at all. Not so much when something happens, but later when other public authorities decide to invest that prior act with some normative power. That's the thing I think Mike would hate to see happen as much as it does. But that's a dynamic which I think is implicitly, if not explicitly, part of our constitutional system. Because public authorities are always faced with the task, whether they're making a law, whether they're construing a law, with trying to figure out whether or not something that happened before is relevant to their present decision-making. And what we find is they will do that whether you allow them to do it explicitly, as occurs now, or whether they will do it implicitly under a system where perhaps Mike would disallow them relying on precedent, but of course they would still do so because it's so natural and inherent in the process of judicial decision-making. This is a little bit of my response. I haven't kept, I can see, I'm almost certainly have gone over it, but that's just another example of not following precedent.
Just make sure we have time for questions. I'll let
90 seconds
Professor
each.
Paulsen have a
okay.
short rebuttal, and then if Professor Gerhart wants to, and then we'll definitely have a few minutes for questions.
Okay, I'll have to do this bullet point style. Michael says that he describes current practice. Justices cite precedent in their decision. I don't disagree with that. I'm questioning whether that really has meaningful force or is merely a cover for a decision you reach anyway, or if it does have meaningful force, in which case they're reaching decisions they ought not to be reaching. That's his essential dilemma. He comes down saying precedent doesn't require that much. You can always get around it and distinguish it. Well, if so, then the idea that it's a precedent-based system is, to some extent, a hoax. Here's his basic dilemma. Does a prior decision really have binding force, or should it be treated as having binding force in a subsequent case, notwithstanding that you would otherwise conclude it is wrong? If he's saying, well, they don't really have that binding force, judges can do what they want, then what are they doing citing precedents all the time? It's just confusing people driving the process underground, okay? It is, in a sense, false advertising. If, as they claim, some of the time, inconsistently, it does dictate their decision, then they are knowingly reaching results they otherwise would conclude are wrong. Final point, on a lot of what he says, we're not that far apart, in that I recognize an information function to precedent. There's an efficiency to seeing things. If I were a Supreme Court justice, perish the thought, I'd cite cases because they're a useful shorthand for explaining legal reasoning you would otherwise reach. Just as I might explain to my kids, well, this is what we did before and it worked for your big brother. But I wouldn't say, this is what we did before, and even though it screwed up your big brother, we're going to do it to you too. You don't need a theory of stare decisis to explain what you would otherwise think is the correct answer, though you might use the past successful correct interpretation as a shorthand for describing the result you want.
Any quick response?
Well, it may not be that vast a difference, but I do think that I think in some respects it's misleading to sort of suggest that what the question of stare decisis boils down to is whether or not it requires the court itself, or maybe even some other authority, necessarily to follow the exact same ruling that was made before. I think that kind of choice is rarely posed in constitutional adjudication. And when it does, of course, get posed, which is the circumstance Mike may be talking about, where the court's explicitly reconsidering a precedent, those are the circumstances in which the court has to figure out, okay, besides just precedent, what are the justifications might matter. Now, Mike did say, and I'll close with this, in his initial comments, which I thought was interesting, well, you know, if you're going to overrule precedent, it's got to be not just because it's wrong, but because there got to be other special justifications. And the question that, I thought I heard you say that.
If it's wrong, I will overrule it because it is wrong.
But the notion that the court would overrule a prior decision, not just because it's wrong, but because there are other special justifications, it's itself, I think, an acknowledgement that precedent has some force within the judicial system.
Okay, thanks. We can now take questions. Yeah.
This question is for Mr. Paulsen. Don't you think that there are some cases where a court might decide to follow precedent, not because the precedent was right, in which case, as you pointed out, it should just reach that reasoning anyways, and not despite the fact that the prior precedent was wrong, but because it occupies a middle category where it's neither right or wrong, but it's permissible, and therefore it does aid stability, just like I might decide with my second child to use the 9 o'clock bedtime like I did for his older brother, not because I think that 8 o'clock would be, that justice demands 8, but I'm going to do 9 in the name of precedent, or because 8 is unjust, but because it's permissible. And so in the name of stability, I'll follow that.
Yeah, I think there is a category of cases where the content of the legal rule you reach doesn't matter. Okay, I would hypothesize, like in a strict common law system, literally a rule of the road. The first time two guys are approaching in their vehicles or horse and buggies, do you stay right or stay left? Doesn't matter, really. But there are huge transaction costs in changing the rule, right? So I think the less consequential the rule, the more that there are, legitimate reasons why you could have chosen one way or another in the first instance. Then it's like, who cares? Who cares? It doesn't, in that case, it literally is more important that the rule be settled than that it be settled right or left, right? So what I would say is that, if, as a practical matter, suppose I'm a Supreme Court justice and there's a new issue that comes up in which I haven't had a great deal of thinking, and it's interesting, and there's been a settled course of decisions, and I can't say that they're wrong. They look sensible to me, make sense to me. I'm not an expert to the contrary. I haven't gotten past the persuasion function of departing from it. And on many legal questions, there's probably a fair range of meaning. And if a court has chosen an answer within that range of meaning, there might be a legitimate reason to stick to it. The rubber hits the road issues that I'm concerned about are the ones where you would otherwise conclude, with whatever degree of confidence you need to reach that conclusion, that precedent decision is wrong, and it is meaningfully wrong. That's the category I'm looking at. I agree with Michael, it doesn't happen often. But sometimes the court says, this is why we are doing it. Planned Parenthood versus Casey is such a case, at least so they say. Wow. So justice, that's a rule of consequence, right? No matter which side you are on abortion or Roe versus Wade, to adhere to a rule that you otherwise would conclude is wrong, which seemed to have been the view of Kennedy and O'Connor because of concerns of perception, fairness, equal treatment, all these policy justifications they argue. That's the core of what I'm looking at. There are probably 2, 3, 4 other cases that legitimately fit within that category. But for all the other ones, I think it's just a cover.
Question over here.
Yeah, actually, I was just going to go to that exact thing. To me, I don't particularly like judges who think they have a corner on right and wrong. Most issues, both sides brief, both sides think they're right, both sides are people of goodwill and intelligence. How often are you really going to get a case where your very stark black and white, it's right, it's wrong, ever applies? And I would say on the big issues, it never happens. But I think I'm just restating what you said.
Yeah. Well,
I'm more concerned that you call it a fraud without any statistics to say how often, if you rely on stare decisis, you're going to rewrite. I think it's inappropriate to portray stare decisis as being a hoax if 99% of the time you rely on stare decisis, you're right. So I'm a little concerned by that. And it's a little ironic that you cited precedents for it being unconstitutional, and you went straight to the text of the Constitution. But anyway.
Thank you for pointing that out.
But so, I don't know.
Let me just answer that generally and sort of generically. I do think that there are right answers to constitutional questions. Okay? Sometimes that's clearer, and sometimes people disagree as to what the criteria are, but if you have a reasonably clear set of criteria, it can produce some easy cases, and it will produce some hard cases. And there'll be some cases where your methodology doesn't lead you to a clear right answer or not. I'm saying that within whatever set of cases you would conclude are by your interpretive method wrong, those are the ones where it makes a difference. As to hoax, maybe that's too strong a word. To the extent, though, that the court is saying we are reaching this decision because of the precedent and not independently on the merits, when in fact what's really going on is they're reaching it independently on the merits and are using precedent as illustrative, I think that is deceptive. It is misleading, and I think you can probably search your own minds, and the attitudes toward precedent that were inculcated in you so far in law school are an indication of that. Is precedent is treated by the courts, at least, as if it is often dispositive independent of what it otherwise would conclude. And I think it might be
Professor
misleading.
Gerhart?
Yeah, I'm wondering how Mike thinks about Bush versus Gore, because the only source of authority in Bush versus Gore is precedent.
Well, I think that question is directed to me, so I.
That's
it. Bush versus Gore is, I think, a very interesting and difficult case. It depends on whether you think Baker versus Carr is correct as an original matter. And then you kind of, I think, have to go in another step. I'm going to assume some fair degree of knowledge here. Bush versus Gore ultimately rests 7 votes on the idea of one man, one vote, and that a set of recount rules that would involve differential treatment or weighting of some votes rather than others wrong. And actually, when I first heard that theory, I thought, oh, that's nuts. And someone said, well, how is that any different from Baker versus Carr, Reynolds versus Sims? And this goes back to a problem I've had since law school. Baker versus Carr is still one of the cases I'm not sure whether it's rightly decided or not. So if I have a theory, if in the end I would conclude that Baker and Reynolds are unsound interpretations of the Constitution, then I would have to say that the further extension of them in Bush versus Gore is wrong. I am just uncertain under Baker versus Carr, which can get us into, I don't buy the equal protection rationale, but you might get there on a Republican form of government clause. So this is one of these questions of which, I just don't have an answer. I don't have an answer.
Can I ask one clarification, Mike? No, there are other questions. Does your critique apply if a judge is, say, 51% sure that a prior precedent is wrong? Because you were starting uncertain, but what if you had nothing else to worry about?
Right.
You're slightly leaning in the direction that's opposite of the, say, well-established precedent. Does your critique apply as full?
That's a great question, and I've thought about it in terms of, interpersonal differences in certainty. Now, you probably have classmates this way, I have colleagues this way, and there are justices this way. Scalia is one of these guys that if it's 51-49, the scale tips, trap shuts, that's the answer, right? And you probably have, classmates like that. Once they're sure, they're dead sure, even if there was only a slight. Other people are probably 70-30 people. And within that middle 40%, they could go either way. Well, I see the reasonableness of your position, so I'm willing to go along. Sandra Day O'Connor type people, mushy, get along. You've probably seen this in faculty meetings. You have your colleagues who are irascible and will stick to their position no matter that they're the only person, and they've been saying this for 20 or 30 years. No, never do. And you probably have people who are more go along to get along, sort of thing. I'm saying that with whatever degree of certainty an individual has, it requires them to conclude. No. At this point, I have concluded that this is right, this is wrong. That's where the theory should kick in.
I'll take one more question, yeah.
I was wondering, because there seems to be saying that if, with stare decisis, that it needs to be seen instead as persuasive authority, that a previous court has done something, and that if they get that and as persuasive, they decide, nope, I think this is wrong, therefore, I'm going to make a new rule contradicting that. Do you think that applies to what he was talking about, that other governmental bodies have to depend on stare decisis as well, and therefore should a state create a law that they say, I know the Supreme Court said this, but we're convinced it's wrong, let's initiate it and see what happens? Fabulous
question. You've caught me, okay? And actually, this is part of a broader theory. Because if my premise is correct, that the meaning of the Constitution is an objective meaning, and courts should not adhere to rules that they are fully persuaded are wrong, shouldn't that same reasoning apply to coordinate branches, right? If the Supreme Court has upheld the Sedition Act of 2007 and a subsequent case comes up, United States versus Gerhart, shouldn't the president refuse to obey the wrong judicial decree on the same reasoning? And actually, for a variety of separation of powers reasons about the division of interpretive authority, I think that the answer is yes. Okay, that each branch is independent in its interpretation of the Constitution, and the logic of my position, it's a somewhat different argument. It requires further steps. It could be next year's lecture, but invite me on a sunny day in the middle of winter when I get out of Minneapolis. But I think the answer should be that each individual is bound by oath to interpret the Constitution faithfully and not to be bound by the faithless departures from it of other branches. That is the reasoning of Marbury. If you read this, The Irrepressible Myth of Marbury article, I conclude from the reasoning of Marbury that the president the Congress, the courts, lower courts, the states are not bound by erroneous constitutional actions of other actors, and that is contemplated as part of the system of checks and balances, a system of decentralized interpretive authority, rather than indulging the myth that the Supreme Court always has it right and their answer should bind everybody else.
Well, we're out of town. I'm sure there will be more questions, but let's thank both of our speakers.